My name is Yolanda Breckenridge. I am 38 years old. I am a pharmacist at a retail pharmacy in Omaha, Nebraska, where I have worked for 11 years. My job depends entirely on precision. The correct medication, the correct dosage, the correct patient, verified against the correct prescriber, every single time, without exception, because the cost of a single unverified detail in my profession is not embarrassment. It is someone's life. I have spent 11 years training my mind to log, to verify, and to never simply trust that something happened the way someone says it happened, when there is a record available that can actually confirm it. My mother, Patricia Breckenridge, died this past March, after 2 years of declining health and congestive heart failure complicated by diabetes, the specific, demanding combination that requires multiple medications on a strict schedule, monthly visits to a cardiologist and an endocrinologist, and the kind of careful, sustained logistical support that aging parents with serious chronic conditions require from someone who actually understands what is at stake if a refill is missed or an appointment is skipped. I drove my mother to every single one of those appointments and every single one of her pharmacy pickups for 2 years. Not most of them. Not the convenient ones. All of them, because I am a pharmacist, and I understood, in a way no one else in my family did, exactly what her medication schedule required and exactly what could go wrong if I let any of it slip. My mother's will, when she died, split her estate evenly between my sister Simone and me. Simone contested it. In sworn testimony to the probate court, she said I had been absent for most of our mother's final 2 years, and that as the one who had actually provided primary care, she deserved a larger share of the estate than the will provided. She told the court I was absent for 2 years. I had the mileage logs for every single one of those drives, not because I ever expected to need them in a courtroom. Because I am a pharmacist and pharmacists log things, it is simply how my mind has been trained to move through the world. Destination, purpose, odometer reading, every trip, in the same small notebook I have used for mileage deductions since the year I got my license. 91 logged round trips, across 2 years, that my sister had no idea existed when she decided to tell a judge a story that was not true. My mother was diagnosed with congestive heart failure when I was 36, 2 years before she died, after a hospitalization for breathlessness that none of us, including her, had taken seriously enough soon enough. She had been managing type 2 diabetes for over a decade by that point, reasonably well, with oral medication, and the kind of careful, lifelong discipline around her diet that I had watched her practice my entire adult life. The heart failure diagnosis changed everything about what her daily management actually required. She was put on a regimen that included a diuretic, a beta blocker, an ACE inhibitor, and her existing diabetes medications, all of which needed to be carefully balanced against each other, monitored through regular blood work, and adjusted periodically by her cardiologist based on how her body was responding. This is not a simple medication list. It is the kind of regimen where a missed refill, a skipped appointment, or a medication taken at the wrong time can produce a hospitalization within days. I understood this regimen the way I understand every patient's regimen who comes through my pharmacy counter, professionally, completely, without needing it explained to me twice. My sister Simone, who works in marketing and has never had occasion to learn the specific architecture of heart failure management, understood it the way most people understand a parent's illness, as something frightening and serious that required support, without ever fully grasping the granular, day-to-day logistics that support actually demanded. My mother lived alone, in the same house in Omaha where Simone and I had both grown up, about 15 minutes from my own home and about 40 minutes from Simone's. She was, for most of those 2 years, independent enough to manage her own daily life with help. She could cook, she could manage her own house, she simply could not reliably drive herself to appointments anymore, partly because of medication side effects that affected her alertness, and partly because of a fall the previous year that had made her understandably nervous behind the wheel. Someone needed to drive her, reliably, on schedule, to the pharmacy and to 3 different specialist offices for 2 years. That someone was me, every single time, because I was the one who understood exactly why it mattered, and exactly what would happen if it didn't get done. My mother was a proud woman, and I want to say clearly that needing this kind of help was never easy for her to accept. She had raised 2 daughters largely on her own after our father left when I was 9, working as a school cafeteria supervisor for over 20 years, and the specific dignity she had built for herself across that career was not something she surrendered easily to the idea that she now needed her own daughter to drive her to the pharmacy like a child being taken to school. The early months of her decline were complicated as much by her own resistance to needing help as by the medical realities themselves. She would sometimes insist, in the first several months after her diagnosis, that she could manage a particular appointment on her own, or ask a neighbor instead of me, in the specific way that proud people sometimes try to distribute their dependence more thinly so that no single relationship has to carry the full visible weight of it. I learned, over time, not to argue with this instinct directly, but simply to make myself consistently available enough that asking me eventually became the path of least resistance, rather than something she had to specifically request and feel diminished by requesting. By the second year, this dynamic had settled into something more comfortable for both of us. She stopped offering alternatives. I stopped waiting to be asked, and simply built her appointments into my own calendar as soon as her doctor's office called to schedule them, the same way I might block out a recurring obligation at the pharmacy itself. It became, in the most literal sense, routine, which is precisely why I never thought to treat any single instance of it as remarkable enough to require proof. I want to give you the actual shape of those 2 years, because the specific, grinding regularity of it is part of what makes my sister's testimony so precisely wrong. My mother's pharmacy refills came due roughly every 30 days, staggered slightly across her different medications, which meant I was picking up or coordinating a refill for her at least twice a month, every month, for 2 years. Her cardiologist wanted to see her monthly for the first 6 months after diagnosis, then every 6 weeks once her medications had stabilized. Her endocrinologist saw her every 3 months. A nephrologist was added to her care team in the second year, once her kidney function began showing the kind of mild decline that heart failure patients on diuretics often experience, adding another appointment every 2 months. I drove her to all of it. I picked her up at her house, I drove her to whichever appointment or pharmacy stop was scheduled, I waited with her, and I drove her home. On the days when multiple errands could be combined, a pharmacy stop on the way to or from an appointment, I combined them, the way anyone managing this kind of sustained logistics learns to do. This was not, I want to be clear, a burden I resented. I loved my mother, and the time in the car with her, twice a month at minimum, often more, became some of the most consistent, ordinary, valuable time I had with her in her final 2 years. Small talk about her garden, her opinions about whatever she was reading, the particular, unhurried conversations that happen naturally between 2 people who are simply in a car together with nowhere else they need to be for the next 40 minutes. Simone visited our mother regularly during this same period. I do not want to suggest she was entirely absent from our mother's life. She came to dinner most weeks, she called frequently, she was present for several of our mother's birthdays and holidays in the specific way that a present, engaged adult daughter is present. What she did not do in 2 years was drive our mother to a single pharmacy pickup or a single medical appointment. Not once. I know this with complete confidence, because I was the one doing it every single time, and I would have known if Simone had ever taken a turn. I never thought to keep a record of any of this for the purpose of someday proving it to anyone. I kept a record of it because I am a pharmacist, and the specific habit of logging mileage for tax purposes is one I had carried since the year I first got my pharmacist's license, and started deducting work-related driving on my taxes. The habit simply extended, without my ever deciding it should, to every drive I made for my mother's care, because by that point, logging mileage was not a decision I made each time. It was simply what I did, automatically, every time I got in the car for any purpose connected to my work or my responsibilities. I remember specific drives the way I imagine most caregiving daughters remember them. Not as a blur, but as a series of distinct, accumulated Tuesdays and Thursdays, because her cardiology appointments fell on Tuesdays and her endocrinology visits fell on Thursdays. For most of the second year, once her care team had settled into a rhythm. I would leave the pharmacy at lunch on those days, drive the 15 minutes to her house, help her into my car, drive the 11 minutes to whichever office had the appointment, sit in the waiting room reading on my phone between patients, drive her home, and return to my own shift, sometimes with barely enough time to eat anything before clocking back in. There were harder stretches within those 2 years that I think about more than the routine ones. The week in the first winter when her blood pressure readings became concerning enough that her cardiologist wanted to see her 3 times in 10 days, adjusting her diuretic dosage incrementally each visit to find the right balance without overcorrecting into dehydration. The month in the second year when her kidney function numbers prompted the addition of the nephrologist, and the specific, frightening uncertainty of not yet knowing whether this represented a serious new complication or a manageable side effect of medications that were otherwise keeping her heart stable. I drove her to every single one of those additional, unscheduled, worrying appointments, often with less than a day's notice, because that is simply what the situation required, and I was the one positioned to provide it. I want to describe the notebook itself, because its specific, unglamorous ordinariness is part of why it became such powerful evidence later. It is a small, spiral-bound notebook, the kind sold in bulk at any office supply store, that I have used continuously since I was 27 years old, the year I passed my licensing exam and started working full-time as a pharmacist. I buy a new one every year or two, as each fills up, and I keep the completed ones in a box in my home office, the same box where I keep old tax returns, because mileage logs and tax records have always belonged together in my mind. Each entry follows the same simple format I settled on years ago, after reading IRS guidance on what a compliant mileage log actually requires: the date, the starting and ending odometer reading, the specific purpose of the trip, and the destination. I learned this format specifically because the IRS, in an audit, does not accept a vague claim that you drove for work purposes. It wants dated, itemized, contemporaneous records recorded at or near the time of the trip, not reconstructed afterward from memory. When my mother's care began requiring regular driving, I simply extended this same habit to those trips, recording them in the same notebook in the same format, because I did not separate, in my own mind, work-related driving from any other significant recurring driving obligation in my life. A trip was a trip. If it had a clear purpose and a clear destination, it went in the notebook, the same way it had for the previous 9 years of my career. By the time my mother died, I had recorded across 2 years 91 separate round trips connected specifically to her care: pharmacy pickups, cardiology appointments, endocrinology appointments, the later nephrology appointments, and the occasional additional trip for things like a flu shot or an unscheduled visit when she was not feeling well and wanted me to take her in to be checked. Each entry had a date. Each entry had a destination specific enough to be verified against an actual pharmacy or medical office's own records. Each entry had an odometer reading that corresponded to a route I drove the same way nearly every time, between her house and whichever destination the trip required. I had never once imagined I would need to produce this notebook for anyone other than my own tax preparer. I certainly never imagined I would need it to disprove a sworn statement my own sister would eventually make to a judge, claiming I had not been there at all. My sister Simone is 42 years old, 4 years older than me, and works as a marketing director for a regional retail chain headquartered in Omaha. She is intelligent, capable in her own professional sphere, and has, throughout our adult lives, occupied a specific position in our family that I think explains a great deal about what eventually happened with the will. Simone has always understood herself as the more naturally responsible older sibling, the one who, in her own account of our shared childhood, looked after me, managed things, kept the household functioning during periods when our parents' attention was elsewhere. I do not entirely dispute this account of our childhood, there is truth in it. What I think happened, over the following decades, is that Simone's identity as the responsible one calcified into something she needed to keep being true, regardless of whether the actual, present-day facts of any given situation still supported it. During our mother's 2 years of declining health, I believe Simone genuinely saw herself as a significant caregiver. She visited regularly, she called frequently, and in her own understanding of what caregiving meant, this regular presence likely felt, to her, like a substantial contribution, on par with whatever I was doing. I do not think Simone set out, at the beginning of those 2 years, to construct a false narrative. I think she gradually came to believe a version of events that flattered her own self-understanding, in the absence of anyone closely tracking the actual, granular distribution of the logistical labor involved. What I cannot extend the same generosity toward is what she did once our mother died and the will was read. The will my mother had drafted 4 years earlier, with the help of an estate attorney, split her modest estate, primarily the house and her retirement savings, evenly between Simone and me. Simone, upon learning this, decided that an even split did not reflect what she believed she had contributed, and rather than raising this directly with me as a conversation between sisters, she retained her own attorney and formally contested the will in probate court, specifically requesting a larger share on the stated grounds that she had served as our mother's primary caregiver, while I had been, in her sworn words, largely absent. This was the moment her flattering self-understanding stopped being simply a private misperception and became something else entirely. A formal, sworn claim, made to a court of law, that was directly and verifiably false. I want to give one more piece of context about Simone, because I think it explains something about the specific shape her contest eventually took. When we were growing up, Simone was, in fact, frequently left in charge of me during the periods after our father left, while our mother worked evening shifts to cover the gap his absence created in the household budget. She was 12 and I was 8 during the hardest stretch of that period, and she did genuinely manage things during those years in ways that were not typical for a child her age, making sure I ate dinner, getting me to bed, handling small emergencies our mother was not home to handle herself. I think Simone has spent the decades since then, in a sense, still living partly inside the identity that period created for her, the responsible one, the one who steps up when no one else can. I think when our mother's decline began, some part of Simone wanted, genuinely and without calculation at first, to be exactly that person again. The trouble was that the actual logistics of this particular decline did not require the kind of generalized responsibility Simone had once provided. They required someone who understood heart failure medication schedules, who could recognize the early signs of fluid retention, who knew which symptoms warranted an immediate call to the cardiologist, rather than a wait-and-see approach. That was never going to be Simone, not because she lacked the will, but because she lacked the specific professional context I had spent a career building. My mother's will was straightforward, by estate planning standards. She had drafted it 4 years before her death, while still in reasonably good health, with the help of an estate attorney in Omaha named Mr. Elliot Nash, whom she had used for various legal matters for over a decade. The will named both Simone and me as equal beneficiaries of her estate, split 50-50, with no conditions attached to either share based on caregiving contributions, because at the time the will was drafted, our mother's health had not yet declined to the point where caregiving was even a relevant consideration. This detail matters significantly, and it became important later in the legal proceedings. The even split was not my mother's response to caregiving she witnessed during her decline. It was simply how she had always intended to divide her estate between her two daughters, decided years before either of us had to drive her anywhere. When my mother died and the will was read, Simone's initial reaction, in the days immediately following, did not suggest any objection. It was approximately 6 weeks later, after the estate had entered the formal probate process, and Simone had had time to sit with her own feelings about the disparity she perceived between her contributions and mine, that she retained an attorney and filed a formal contest, requesting that the court deviate from the will's even split and award her a larger share based on her claimed role as primary caregiver. I want to be precise about what this legal claim actually required her to assert, because it is not a small or vague accusation. To request a larger share based on caregiving contribution, in the framework her attorney constructed, Simone needed to establish, to the court's satisfaction, both that she had provided substantial, sustained caregiving, and that I had not, that the disparity between our actual contributions was significant enough to justify deviating from what our mother had explicitly written. This required her, specifically and under oath, to characterize my involvement in our mother's care as minimal or absent. She made that characterization formally in a sworn declaration submitted to the probate court, stating that I had been largely absent from our mother's care during the final 2 years of her life, and that she, Simone, had served as our mother's primary support during that period. I did not see this declaration until my own attorney received it through the formal court filing process. Reading it for the first time, in my own kitchen, I felt something colder than anger, the specific, clarifying stillness of understanding that I now needed to treat my own sister's words as evidence to be disproven, rather than as family disagreement to be smoothed over. I retained my own attorney within a week of receiving Simone's filing, a probate specialist recommended by a colleague who had gone through a similar, if less contentious, estate matter of her own. My attorney explained the basic shape of what was happening. Simone's contest, if successful, would not void the will entirely, but could result in the court approving an unequal distribution if Simone could sufficiently demonstrate that her caregiving contributions justified deviating from the document's stated terms. This meant the entire legal question turned, in large part, on a factual dispute about who had actually done what during our mother's final 2 years, precisely the kind of dispute that, in the absence of clear documentation, often comes down to competing testimony, family reputation, and whichever sister the judge finds more credible on the stand. I understood, from my very first meeting with my attorney, that I needed more than my own account of those 2 years. I needed something that did not depend on anyone believing me over my sister. I remember the exact moment I mentioned the notebook to my attorney, somewhat in passing, during our second meeting, while we were discussing what evidence I might be able to gather to counter Simone's claims. I said something like, "Well, I do have my mileage logs from driving her to all her appointments, if that's useful for anything." I remember my attorney's expression changing immediately, the specific, focused attention of someone who has just realized a case that seemed like it would come down to competing memories, might actually have hard, contemporaneous documentation behind it instead. She asked me to bring in every notebook I had used during the relevant 2-year period. I brought in 3, the one that had been in use when my mother's diagnosis began, the one that covered most of the middle period, and the one I was still using when she died. My attorney went through them carefully, cross-referencing the entries connected to my mother's care against the dates, and confirmed what I already knew: 91 separate, dated, itemized round trips, each with a specific destination and purpose, recorded contemporaneously, in my own handwriting, in a format that had been maintained consistently for over a decade before any of this litigation existed. She said, "Yolanda, this is exactly the kind of evidence that wins this kind of case. not because it is dramatic, because it cannot be argued with the way memory can. Simone is asking the court to believe a story about who was present and who was absent. You have a contemporaneous, dated record that either matches the actual medical and pharmacy records, or it doesn't. If it matches, there is no story left for her to tell. My attorney explained, in that same meeting, the legal mechanics of why this kind of documentation carries the specific evidentiary weight it does. Courts, she told me, are generally instructed to give greater weight to records created contemporaneously, in the ordinary course of a person's regular habits, than to testimony reconstructed after the fact from memory, particularly when that testimony is being offered in a context where the witness has a direct financial incentive to remember events in a way that favors her own claim. My notebook entries, predating any dispute by years and serving an entirely unrelated original purpose, were about as far from a self-serving reconstruction as evidence could be. She also cautioned me, carefully, that having strong evidence was not the same thing as the matter being settled. Simone's attorney would have every opportunity to challenge the authenticity of the notebooks, to question whether the odometer readings could be verified independently, to suggest that I might have filled in or altered entries after the fact once litigation became likely. I spent an uncomfortable hour that same afternoon allowing my attorney's office to photograph and timestamp every single page of all 3 notebooks, establishing a clear chain of custody from that point forward, specifically to foreclose any argument that the records had been tampered with after my mother's death. I want to walk through the specific content of Simone's sworn declaration, because the precision of what she claimed matters for understanding exactly how completely the mileage logs would eventually contradict it. In her declaration, submitted under oath to the probate court, Simone stated that during the final 2 years of our mother's life, she had personally managed the majority of our mother's medical care coordination, had been present for the substantial majority of medical appointments, and had taken on primary responsibility for ensuring our mother's medication regimen was properly maintained. She stated that I, by contrast, had been largely unavailable during this period due to my work schedule, visiting our mother only occasionally and rarely, if ever, accompanying her to medical appointments or pharmacy visits. She supported this characterization with several specific anecdotes in her declaration, describing, for instance, a particular cardiology appointment she claimed to have driven our mother to herself, and a period she described as several months during which she said I had been entirely absent from our mother's care due to a demanding stretch at the pharmacy. My attorney and I went through each specific claim in Simone's declaration against my notebook entries and against the actual medical records we were able to subpoena from my mother's cardiologist, endocrinologist, and nephrologist, as well as the pharmacy's own dispensing records, which document not just that a prescription was filled, but in many cases, who physically picked it up. Since Nebraska pharmacy practice generally requires some form of identification or signature for controlled substances and many other prescriptions as a matter of standard procedure. The specific cardiology appointment Simone claimed to have driven our mother to herself did not match any appointment date in the cardiologist's own scheduling records, as one where Simone's name appeared in the office's visitor sign-in log, while my notebook entry for that same approximate period showed a logged trip to that same cardiologist's office, on a date that did match the practice's own appointment records exactly. The several-month period Simone described as a stretch where I had been entirely absent due to a demanding period at work corresponded, when we checked my actual notebook entries against that exact window of time, to one of the periods with the highest frequency of logged trips in the entire 2 years, 11 separate round trips in a 10-week span. During a period when my mother's cardiologist had increased her appointment frequency in response to a concerning change in her blood pressure readings. Simone had not simply misremembered a minor detail. She had described, under oath, the near opposite of what the contemporaneous record actually showed. Mr. Elliot Nash, the estate attorney who had drafted my mother's will 4 years before her death, became a relevant figure in the proceedings not because he took a side in the dispute between Simone and me, but because his own contemporaneous records of preparing the will helped establish the second key fact my attorney needed to build the case: that the even split had never been conditioned on caregiving performance, because at the time the will was drafted, no caregiving need yet existed. Mr. Nash's own file notes from the drafting process, which my attorney requested through the discovery process, documented that my mother had been explicit, during their original meetings 4 years earlier, that she wanted her estate divided equally between her two daughters regardless of any future circumstances, specifically because, in her own words as recorded in his notes, she did not want her daughters competing with each other over who had done more for her. I want to sit with that detail for a moment, because it landed for me when my attorney first showed me Mr. Nash's notes, with a weight separate from the legal proceedings themselves. My mother had anticipated, 4 years before her own decline even began, the exact dynamic her daughters might eventually fall into around caregiving and inheritance, and had tried, in the clearest way available to her, to prevent it, an even split, with no conditions, specifically so that neither of us would ever need to compete over who had loved her more correctly. Mr. Nash, when his own discovery deposition was eventually taken as part of the broader proceedings, was not asked to testify about who had actually provided care during the final 2 years. He had no personal knowledge of that period, since his involvement with the family had been limited to the original drafting 4 years earlier. His role, formally, was simply to confirm the document's history and my mother's stated intent at the time it was created, establishing clearly that the even split was never meant as an assessment of caregiving merit, but as my mother's deliberate, considered wish. It was Mr. Nash, however, who made the specific discovery request that ultimately proved decisive, not because he had any reason to suspect what it would reveal, but because requesting mileage and travel logs from both parties is, in his professional experience, a routine step in any probate matter where caregiving claims are central to the dispute. He told my attorney, later, that in over 20 years of estate practice, it was the first time such a routine request had ever produced a record this complete, this specific, and this thoroughly corroborated by independent third-party data. The formal discovery request for mileage and travel logs went out to both Simone and me roughly 2 months into the proceedings, a standard step my attorney explained was common in caregiving-based, will contests specifically, because courts have grown accustomed to these disputes, coming down to competing, unverifiable claims of presence and absence. I produced my 3 notebooks in full, along with a typed summary my attorney's paralegal prepared, organizing all 91 entries connected to my mother's care chronologically, with each entry cross-referenced against the corresponding medical or pharmacy record we had been able to obtain through our own subpoenas. The summary document ran to several pages, but its structure was simple: date, destination, purpose, and a checkmark indicating whether an independent third-party record, an appointment scheduling system, a pharmacy dispensing log, corroborated that the trip had in fact occurred. Simone, in response to the same discovery request, produced no comparable record. Her attorney's response indicated that she had not maintained any formal log of her visits or any trips connected to our mother's care, and that her testimony regarding her caregiving contributions would rest on her own recollection and the recollection of any witnesses her attorney intended to call. I do not believe Simone had any way of knowing, when she filed her original sworn declaration months earlier, that I would be able to produce 91 independently corroborated, contemporaneously dated records directly contradicting her specific claims. I believe she assumed, reasonably given how most families navigate exactly this kind of dispute, that the matter would come down to her word against mine, decided by whichever sister the court found more sympathetic or more credible on the stand. My attorney told me, during this period of waiting to see what Simone's side would produce, that in her own experience handling caregiving-based will contests, the overwhelming majority resolve exactly the way Simone seemed to be expecting this one to resolve, through a kind of credibility contest, where the court weighs each sister's testimony, considers any witnesses either side calls to corroborate their version of events, and ultimately makes a judgment call about which account seems more plausible. In the absence of hard documentary evidence either way, she said cases with this kind of contemporaneous, third-party corroborated record on one side and nothing comparable on the other were, in her words, vanishingly rare, and almost always decisive once they appeared. The evidentiary hearing took place on a Tuesday morning in late summer, in a probate courtroom in downtown Omaha, considerably smaller and quieter than the dramatic courtroom settings television tends to depict, a modest room, a single judge, both attorneys, Simone and me seated at separate tables with our respective counsel. Simone testified first, repeating, under oath and in person, the substance of her original written declaration, that she had been our mother's primary caregiver, that I had been largely absent, that the specific cardiology appointment and the several-month period she had described in her declaration represented an accurate account of how our mother's final 2 years had actually unfolded. My attorney's cross-examination of Simone was not aggressive in tone, simply precise. She asked Simone to confirm the specific date she had claimed to drive our mother to the cardiology appointment in question. Simone gave an approximate date. My attorney then introduced, as an exhibit, the cardiologist's own scheduling and sign-in records for that exact period, which showed no record of Simone's name at the practice on any date within the window she had described, and which showed, instead, a sign-in matching my own name on the date that corresponded exactly to my notebook entry. She asked Simone to describe, in more detail, the several-month period she had characterized as a stretch where I had been entirely absent from our mother's care. Simone described it largely as she had in her declaration. My attorney then introduced my notebook entries for that exact window, alongside the cardiologist's own records showing an increased appointment frequency during precisely that period, and asked Simone whether she had any explanation for why 11 separate, independently corroborated round trips appeared in the record during the exact stretch she had sworn I was absent. Simone did not have an explanation. She said, eventually, something close to, "I don't remember it that clearly, I suppose," and I sat at my own table, beside my attorney, and watched my sister's sworn account of 2 years of our mother's life come apart against a small spiral notebook I had filled out, almost unconsciously, the same way I have filled out a mileage log every working day of my adult professional life. The full accounting, once my attorney had walked the court through all 91 entries and their corresponding corroboration, was unambiguous. Of the 91 logged round trips connected to our mother's pharmacy refills and medical appointments across 2 years, 87 were independently corroborated by either the pharmacy's own dispensing records or the relevant medical practice's scheduling and sign-in logs. The remaining 4 were trips for which the corresponding third-party record either did not specify who had accompanied our mother or had not retained records going back that far, but none of those 4 trips contradicted any independent record either. Across the same 2-year period, the combined medical and pharmacy records showed exactly 0 instances of Simone's name appearing as the accompanying party at any pharmacy pickup or medical appointment. Not a single one, across 2 years, and what the records eventually confirmed was a minimum of 104 total medical and pharmacy visits during that window, accounting for some additional ad hoc visits not connected to the routine recurring care I had documented myself. My attorney's closing argument did not need to be lengthy or dramatic. She simply walked the court through the numbers a final time. A sworn declaration claiming primary caregiving status, submitted by a party who could produce no contemporaneous record of her own, directly contradicted by 91 independently corroborated trips logged by the other party, as a matter of an entirely unrelated, years-long professional habit that predated this dispute by nearly a decade. The judge's ruling, issued several weeks later in writing, found that Simone had failed to meet her burden of demonstrating that her caregiving contributions justified deviating from the will's clearly stated, evenly split terms, and specifically noted, in the written decision, that her sworn testimony regarding the extent of her own caregiving and the extent of my absence had been directly and substantially contradicted by independently corroborated documentary evidence. The will's original, even split was upheld in full. I did not feel triumphant reading that ruling. I felt, mostly, the specific, complicated exhaustion of having had to prove, formally and under oath, something that should have simply been a known and acknowledged fact between two sisters who had just lost their mother together. Simone and I have not fully repaired our relationship since the hearing, and I want to be honest about that rather than offering a tidier ending than the actual situation has produced. We have spoken twice since the ruling, both times briefly and carefully, both times avoiding any direct discussion of the hearing itself or the testimony that produced it. She did, in the second of those two conversations, say something close to an acknowledgement, not a full apology, but an admission that she said, "I think I convinced myself of something that made me feel better about how things actually went, and I should have just talked to you instead of going to court." I told her I appreciated her saying that, and that I hoped, eventually, we could find our way to an actual conversation about it, rather than the careful, distant politeness we have settled into since the ruling. I have thought often about why Simone never thought to ask me directly, before filing her contest, whether I had any record of my own involvement in our mother's care. I think the answer is simply that the idea of a contemporaneous, independently corroborated record never occurred to her as something that might exist, because she had never kept one herself, and it did not cross her mind that I might have, almost by accident, kept one for 2 full years without ever once mentioning it, because it had never seemed significant enough to mention. I have continued, in the months since, the same habit that produced those 91 entries, still logging my mileage, still filling the same kind of small spiral notebook, for the same original, unglamorous tax purposes that started the habit 15 years ago. I do not expect I will ever again need a notebook to defend myself against my own sister in a courtroom. But I have a different relationship to the habit now than I did before any of this happened. A quiet, specific awareness that the things we record without ever expecting them to matter sometimes turn out to be the only thing standing between the truth and whatever story someone else has decided to tell instead. I sold our mother's house, as the will required, splitting the proceeds evenly with Simone, exactly as our mother had always intended. I did this without any sense of vindication, because by the time the sale finally closed, several months after the ruling, the entire process had cost both of us considerably more, in legal fees, and in whatever remained of our relationship's ease, than either share of that inheritance was actually worth in dollars. I do not think Simone walked away from this believing she had truly lost anything beyond the larger share she had hoped for. I think, in the quieter moments since, she has had to sit with something more difficult than losing a legal argument. The knowledge that she put her own sister through a public, formal reckoning over something that was never actually true, and that the record of that reckoning now exists permanently, in a court file, regardless of whatever private understanding we eventually reach between just the two of us. I am 38 years old. I am a pharmacist. My entire profession is built on the discipline of verifying rather than assuming, of trusting a record over a recollection, because the cost of trusting memory alone, in my line of work, is sometimes a person's life. I had no idea, for 15 years of keeping a simple mileage log for entirely unrelated tax purposes, that the same discipline would eventually be the only thing standing between my mother's actual final 2 years, and a version of them my own sister decided, under oath, to tell instead. What I keep from this story is the notebook itself, 3 of them, now filed away in the same box as my old tax returns, holding 91 dated, itemized records of 2 years spent doing the unglamorous, recurring work of making sure my mother's heart medication, her diabetes management, and her kidney function were never compromised by a missed refill or a skipped appointment. I keep them not as a trophy from a legal victory, but as the actual, accurate record of what those 2 years were, regardless of what anyone else later needed them to have been. I keep Mr. Nash's file notes, my mother's own words to him 4 years before any of this happened. She did not want her daughters competing over who had done more for her. I keep them because they tell me my mother understood, long before her own decline began, exactly what grief and inheritance can do to two sisters who loved her, and tried, in the only way available to her at the time, to prevent it. And I keep the specific, quiet clarity of having told the truth, formally and completely, not because I needed a court to validate 2 years of driving my mother to appointments. I would have driven her to regardless of whether anyone ever knew. But because the truth, once it was challenged directly and under oath, deserved to be defended with something more solid than my own word against my sister's. She told the court I was absent for 2 years. I had the mileage logs for every single one of those drives. 91 trips, 87 independently corroborated, 0 belonging to her. The record was never built to win an argument. It simply could not lose one. That is what I keep. If you stayed until the end, thank you. This story is for everyone who has done years of quiet, unglamorous caregiving for a parent, never expecting to need to prove it to anyone, only to have a sibling rewrite the record once an inheritance was on the table. The work you did is real whether or not you ever have to defend it formally. But if you ever do have to defend it, a contemporaneous record beats a competing memory every single time. I want to say one practical thing clearly. If you are caregiving for an aging parent, even informally, even without ever expecting a dispute, keep a simple record. Dates, destinations, purposes. Not because you expect to need it in court. Because the habit of writing things down, consistently and without drama, is sometimes the only thing that can speak for you later, when someone else's memory of events has quietly rewritten itself into something more flattering than the truth. And if you are the sibling who did less and has started to believe you did more, it is not too late to simply ask the person who was actually there, before you decide your own version is the one worth defending under oath. Drop your city in the comments. Tell me if you've ever had to prove your own caregiving against a sibling's false account. I read every single one. Subscribe, hit the bell, share this. More stories coming. I'll see you next time.